Good afternoon and welcome to Greenfields YouTube channel with myself, Raheela Hussain, the Principal Solicitor of Greenfields Solicitors. We are a firm of specialist UK immigration and human rights solicitors, having been established close to 12 years ago in March 2008, and in this firm we specialise in all types of UK immigration law applications. Since establishing this firm in 2008, we have undertaken a wide variety of work, including applications for clients both within the UK and outside of the UK. The type of immigration work we undertake on a routine basis has been appeals work, spouse visas, fiancé visas, deportation cases, and always we have had heavy demand in the area of legal assistance for overstayers. More recently, the firm has undertaken a large amount of cases for clients who have overstayed their visa and seek to regulise their legal status in the UK by obtaining lawful status. So today's video is going to focus on a very, very popular topic at Greenfields Solicitors, which is, again, overstayers. Now, I have done previous videos on overstayers on YouTube previously, and you may have viewed these or you may wish to view my previous videos. So today's video is an update on the law surrounding overstayers as of 2019. I should let you know that the information I provide today is just that, it's general information, and it is in no way or should in no way be relied upon as legal advice because it does not constitute legal advice. In the event that you require assistance or advice from us, then please do contact us and we can arrange an appointment for our viewers or our clients, hopefully, to see me or one of the solicitors at the practice, and we shall be providing our best contact details as well. So, with regards to immigration at the moment, in 2019, as people will know, there is a heavy emphasis on Brexit at the moment. But this video will not be speaking about Brexit because the kind of immigration work we do at Greenfields Solicitors, in particular for overstayers, they are not in any way at this time, at the time of this video, impacted by Brexit, as our overstay clients are predominantly from non-EU countries. So for example, they will be from Africa, or they will be from Mexico or India or Kenya, China, USA, New Zealand. So we have clients from all over the world who are in the UK who overstay whichever visa that they entered in on. For example, we have clients who have overstayed student visas, tourist visas, perhaps they entered on a fiancé visa, but for whatever reason the marriage did not occur. Sometimes we assist people who have entered on a marriage visa, obtained a spouse visa whilst in the UK, but the marriage has not worked out, and they want to know what other options are available to them rather than them remaining unlawful in the UK. So at the moment, the application fees for somebody who wishes to submit an application to regulise their legal status or perhaps vary their legal status under the private life laws under Article 8, they are currently 2,033 in total. 1,033 compromises of the actual Home Office fee, and the remaining £1,000 is a contribution towards the immigration health surcharge. So in total, an application at this time made to the Home Office for either regularisation of legal status or perhaps variation of legal status, if you're looking to vary your legal status to a private or family life application, will be in total 2,033. Home Office fees generally are increased every spring, as we have seen. So these are the current fees. In addition, I should let you know, when we lodge applications at the firm, we are seeing quite a fast turnaround from the Home Office. We are seeing decisions made in clients' cases usually within 6 to 12 months, which is a good speed turnaround for clients when they submit an application. In addition, appeals, when we lodge appeals, they are also taking about 6 months for a decision. So it's a lot more quicker now than it was previously, as sometimes our clients could be waiting 2 or 3 years, but we have noticed under the current system this year that we are getting decisions and court hearing dates a lot quicker. So something that is a predominant law that is relied upon when a client comes to me and says, Mrs Hussain, for example, I've overstayed my visa, I entered in the UK on a visit visa in, shall we say, 2006. The visit visa was valid for 6 months. However, I did not return to my native country, and for argument's sake, I'll just say that's Nigeria. So I did not return to Nigeria within 6 months, and I have remained here. Now I've been here for several years. I do not want to return to Nigeria, or I cannot. And they will explain to me their personal circumstances as to why they feel they cannot or will not return to Nigeria. And often, a lot of the discussion I have with my clients was usually centre on the fact that they have established a life in the UK during the years that they've been here. So for they will tell me, I have established a private life. They may have a partner in the UK, they may have had a child in the UK, or they may even be single, but they have their own reasons as to why they cannot or will not return to Nigeria. So obviously I will go through those reasons with them and advise them on how good their merits are based on the current laws. And that's what happens when you book a consultation with us at Greenfields Solicitors. We will go through your case. We offer 40-minute consultations, which gives clients sufficient time to explain their circumstances, their immigration problem, and for us to advise them and let them know of their options and how strong a case is, in our professional opinion, if you were to make an application to the Home Office. So when clients come to us, they may have a whole medley of reasons as to why they've come, and I have going to go through a few of the kind of cases that we've handled here in the last 12 months or so. And these range from a single lady who came from a country in Nigeria, a country in Africa, not Nigeria. In this case, I think she was from Ghana, and she actually said, I wish to remain in the UK. I've been here for a number of years and I cannot return to Ghana because my family, my mother, my father, my brother and my sister have actually relocated. They're now living in the US, and therefore I cannot go back to Ghana as a single lady. She was approximately around 30 years of age, never married, never had children, and she was unable to get a visa to live in the US with her family there. And because she was illegal here, she was obviously very fearful. So we actually lodged an application to the Home Office requesting that she be granted leave to remain on a discretionary leave outside of the immigration rules basis. And we argued that there were it's a very important sentence I'm about to say here, that there are very significant obstacles as to her reintegration back to her home country of Ghana. Now, I will refocus on the phrase very significant obstacles in more detail as this video progresses, but it is something I would like you as my viewers to bear in mind, because when the Home Office decide applications, they are very, very much focused on whether the person that we're trying to obtain leave for can show and prove that there are very significant obstacles as to their reintegration into their home country. Because under the UK immigration rules, if you are able to prove that there are very significant obstacles as to your reintegration into your home country, then the UK government can grant you leave to remain in the UK. So the other kind of cases that we touch upon are those where I have a client who's in the UK, a gentleman from Morocco, and he formed a relationship with a lady and he was cohabiting with her for a period of about 3 years, and he approached our firm and asked for assistance. Now, under the cohabitation rules, generally, if one has been cohabiting with somebody who has a form of permanent legal status in the UK, usually indefinite leave to remain, British citizenship or permanent residence, and they may make an application to remain in the UK on the basis that they have a established partnership and relationship with that person, and therefore they should be granted leave to remain. Obviously, it's very important to provide with these applications to the Home Office evidence of their relationship and evidence of their cohabitation, because the Home Office, when they assess applications, they do look at the documentary evidence that is submitted by the client, as often that is what gives the Home Office the right to either allow and grant that person a visa or deny or refuse them a visa. So we cannot emphasise how important it is that when we submit an application to the Home Office, we do try for our very high standards to enclose as much documentation as possible for the client to support their application for leave to remain in the UK. Now, with this Moroccan gentleman, we were able to prove that the relationship was genuine, that it was long-standing, and we were also able to prove that there were very significant obstacles as to why his British partner could not leave the UK and return with him in Morocco and for them to continue their lives there. Now, the kind of obstacles that surrounded this lady, without going into too much detail, included medical problems. So she needed medical assistance, medical help in the UK, which would not have been easily or in any way attainable in Morocco because there were cost issues. How would she afford to pay for that? How would she even get a visa to permanently reside in Morocco? In addition, she had all her employment in the UK, she had her family in the UK, she had her ties in the UK. So when we presented this case to the Home Office, we argued heavily that the British partner could not relocate to Morocco due to very significant obstacles that she would have to face. And we obviously put a lot of documentary evidence into back up that claim. And we argued that the Moroccan gentleman should be granted leave to remain on the basis that they had a relationship of several years, they lived together, it was an established and genuine relationship, and we were pleased to learn that our client was granted the leave to remain visa that we had granted for. That allowed him legal status after so many years. So obviously as a couple they were extremely happy, and the gentleman then proceeded to find lawful employment, and they've continued their lives ever since. Now we also have clients who come to us and they have children, so we might have overstayer families who approach Greenfields Solicitors, and they may say, Mrs Hussain, I've been here, on a student visa, however I cannot continue studying because of course fees, or the institution let me down, or something or another has gone wrong. I now have children in the UK, my partner is also from abroad, so what do I do? And sometimes when the children have been here either over the period of 7 years, or they have been born here and lived in the UK continuously for 7 years or more, there are laws that allow them to make an application to remain in the UK on the basis of what many people coin as the 7-year rule. So where a child has remained in the UK for more than 7 years, or has been born in the UK and lived here for more than 7 years, if we can again prove that there would be very large significant obstacles for that child to relocate with their parents back to their parents' native country of origin, it's also possible for not only us to apply and obtain legal status for that child, but also any other children of the family along with the parents. So when we have made applications under the 7-year rule, if we abbreviate it to that, then at Greenfields Solicitors we have obtained legal status for both the child, the parents and the entire immediate family. Sometimes there can be 4, 5, 6 family members living unlawfully up until that point, until we are able to assist them to obtain regularisation of legal status. Again, they would get the 2.5-year visa under the 10-year route to settlement, but they obviously are very happy that after many years of living unlawfully and scared and so many issues they've had to encounter and difficulties in the UK, they've obtained lawful status, and then they can live freely, they can travel, they can work. There's an absolute life of freedom in front of them then once they obtain legal status. We also have cases where I have partners coming to me, so it's just partners themselves coming. They might have a British child, husbands and wives with 1 or 2 British child, so perhaps the foreign migrant has married somebody who's British or has indefinite leave or permanent residence, and then they submit an application based on our advice to the Home Office, because not only do they have a British citizen partner, but they also have a child who has automatically obtained British citizenship through their parent. And then you would argue the exception criteria within the immigration rules. So there are lots and lots of laws and case laws that go into arguing a case for overstays. It's not just a matter of filling in an application form, paying the Home Office fee, putting some documents in and hoping for the best. When you submit a case to the Home Office, you have to be really well aware with overstay cases, and particularly the law. So there'll be a lot of arguments maybe under Article 8 of the Human Rights Act, which is the right to private and family life. You'll also be arguing under Section 55 of the Borders, Citizenship and Immigration Act, which is with regards to the best interests and primary interests of the children. You will also be arguing paragraph 276 ADE of the immigration rules. You will also be arguing the exception criteria potentially under the immigration rules, and you have lots of case laws that you will rely on depending on if there are children in the family or not. Now, in regards to children of the family, whenever we argue the best interests of a child, i.e. they should remain in the UK rather than being sent back to their native country of origin of their parents, we have to also make reference to the case of Section 55, as I mentioned, Section 55 of the Borders, Citizenship and Immigration Act 2009, and the case law of ZH Tanzania, which is a precedent case law. and these centre on what's the primary consideration, which is the best interest of a child. Now, it's difficult to understand how the law works and operates when you're not in practice as a solicitor or somebody who specialises in immigration law. So if you have any doubts whether your case is strong, or whether you want to find out whether you have a case or have any queries, then we would always suggest that you obtain legal advice from a firm of solicitors who are reputable in their field of practice, rather than just going on Google or doing research on the internet. As often I encounter clients who come to me during the consultation and they say to me, I've read this on the internet, or I've heard this from my friend, or people are saying this. And more often than not, I have to correct them and let them know what the exact law is, what the actual law states. Word of mouth can be very, very dangerous in the legal field, because the only way you will know if your case has strength and whether it is a case worth pursuing is by getting definitive legal advice from a practitioner such as myself, who has years and years of experience in a particular field. So please do not listen to things that you see or hear. If you need to raise anything, if you have any questions, if you want to get advice that's definitive and you can rely on, then the best thing is to book advice and consultation. Now, as I touched on earlier, if you would like to book a consultation with Greenfields Solicitors, then please do contact us. We aim to reply to inquiries within 1 working day. Thankfully, we are a well-established, well-respected and very busy firm, so we have a very high demand for our professional services. We have our phone number shown, which is on screen now, or you can also email us for an appointment, which is often more preferred because we can get back to clients very quickly. Our email address is info@greenfieldsolicitors.com. That's info@greenfieldsolicitors.com, whereby you can actually send us an email with a 1 or 2 line description, just saying what your immigration problem is and requesting an appointment, and one of our team members here will reply to you promptly. We do aim to reply, like I said, within a working day and offer you an appointment if we can assist you. And if we can assist you, we'll invite you for a consultation either to our North London offices, or for clients who are outside of London and find it difficult to travel in, then we also offer telephone consultation advice, where myself or one of the other solicitors can give you telephone advice on your particular case. And all cases are treated with the highest confidentiality, so you can be assured that when you approach Greenfields Solicitors, your case will be treated with the utmost respect, courtesy and confidentiality and professionalism, which is what we pride ourselves on here. So I hope this brief video has been of some good general information to our viewers, and if you have any further inquiries that you would like to raise on your particular case, or you want to share this video with somebody who might need our help with regards to overstaying and making an application for regularisation of legal status, please do feel free to share this video. And again, I thank you for watching. My name is Raheela Hussain of Greenfields Solicitors, Principal Solicitor, and until we speak again.